Welcome, everyone. I am Justin Paperni with White Collar Advice and Resilient Courses, and I'm proud to welcome my colleague and friend to the program today, Benson Varghese. How are you, bud?
I'm doing great. Thanks for having me.
Of course, I want to jump right in and get some of your thoughts as a white collar defense attorney in Dallas and uh, offer some advice for defendants. That's why they come to this channel. There's been a very large indictment here out of Southern California where 25 defendants were indicted in a healthcare case. And one of the defendants called me and said, they indicted me for conspiracy. I don't even know some of these people. In your career as a defense attorney, can you offer some insights on exactly what it means to get indicted for conspiracy?
Absolutely. So, conspiracy charges are one of the most powerful tools in a federal prosecutor's toolkit. It is commonly used and it gives the government a lot of advantages on how they're going to proceed.
Mm-hmm.
Essentially, they're going to say multiple people formed a conspiracy to commit some federal offense. And that term conspiracy allows them to bring in a small or large group of people, charge them all with the same offense, and it is not necessary for the government to show that any one actor knew the exact
Mm-hmm.
extent of the conspiracy, which is why you run into these situations where person A is calling you and saying, "Hey, I've never heard of person GHI, but they're all named in this indictment against me."
Well, we saw a lot of that in the Varsity Blues case where some of the defendants were like, I in California, I had no idea what this person's doing in New York, but we're part of a conspiracy.
Absolutely.
So let's transition to someone's indicted out of the blue. Many of the defendants in this case had no idea what's coming. What's the next step for them? And give us some idea. Someone's indicted. What should they do next?
Okay. The first thing you want to do, actually, whether you're indicted or you receive some sort of notice that you're under investigation, whether it's a target letter or there's a warrant executed at your job or house, the very first thing you want to do is speak to an attorney
Mm-hmm.
and speak to no one else. And that's extremely important. I'm going to narrow my answer right now to what happens after an indictment. In the federal system, once you have an indictment, the prosecutors themselves are constrained a little bit more than they otherwise would be, because even as recently as 2017, there's been a memo handed down by the Attorney General that says you guys need to proceed on the highest provable count. And once there's an indictment, the government's saying, "Hey, this is our highest provable count."
Mm-hmm.
So after an indictment, it is much harder to change the actual charge. So what you're doing is a massive amount of damage control.
Mm-hmm.
You'll hear the term proffer thrown around a lot, and especially in conspiracies, there might be a value to you talking to government agents.
Mm-hmm.
But notice the difference between talking to a government agent on your own, which is going to be taken as a confession, versus talking to a government agent through the protection of an attorney who has set up a proffer agreement. Is one is a confession, and the other is something that could be extremely valuable for you.
So
In
let
terms,
so I want to jump on something you mentioned in hiring a lawyer. And later this, I'm in Los Angeles today. Later this week, Benson is throwing a federal white collar seminar conference. I don't know what happened or who convinced him. He's invited me to speak. I wish everyone
really happy.
looking forward to attending. One of the things I'm going to discuss in this conference and speaking to lawyers and everyone that will be there is how a defendant can begin to reconcile and understand the government's indictment. Right? I was that defendant who was in trouble. I'm like, I didn't do anything wrong. It was an aggressive corporate culture. Everybody did it. I was on the periphery. I'm not the bad guy, and I just continued to spin tails. So if someone comes in, tell us a little bit about your without indicting them, because it is only an indictment, but we know a lot of indictments lead to a guilty plea. It can be, how do you disarm? I needed disarming from my lawyer to continue to view me as a good person rather than this terrible thing that was listed in the indictment. So walk us through how you help someone even get to, yeah, maybe I made some bad choices, because I know that could get them to accepting responsibility sooner. Touch on that, please.
So the very first thing I want to do as their attorney is build rapport. And part of that is just explaining how different the federal system is from even any other criminal system. And sometimes I'll jokingly say it's almost un-American how the federal system of criminal prosecution works, because a lot of the things that you might naturally believe, proving punishment evidence perhaps beyond a reasonable doubt, whether or not hearsay statements come in during sentencing, what can be used in sentencing, it's so foreign to anyone that's not been in the system. Even for the folks that love, your Law and Order TV shows, this is not what you see on TV. It's so foreign. So I start with kind of a primer on, well, how does this work? How did the government get to you? How did you get in their crosshairs? What happens from here? And so explaining that system, even though it's often not good news, helps them understand I've been here before, I've walked people through this process, and there is a lot that you can do, even in the system that at times seems arcane and punitive, to really help a person. And that's true even after an indictment. So walking them through what to expect, and then allowing them to tell me, well, here's what I know, here's what I've seen. Yeah, I'm not the worst actor in the world, or even in this conspiracy, but I get that the prosecution has such a great amount of power that only by being honest can I enable my attorney, my defense team, to really help me the way I need to be helped.
To everyone watching this, the most important thing you can do as a defendant, besides retaining someone like Benson, a clearly capable lawyer, is recognizing that it is in your interest to speak openly and honestly. It really is an inverted system. The more you share and purge, as terrible as it may be to describe, it will help you. It is in your interest. So if you are under investigation, or if you've received that letter or been indictment, your lawyer cannot help you. I get too many emails from people who blame their lawyer. Then when I speak with them and investigate, the defendant did not do enough to convey to the lawyer all of the facts. The lawyer could not properly defend them. You have to own that as a defendant. You mentioned something earlier when you're meeting with a potential client or new client. You'll learn how they became a target of the investigation, which leads to cooperators. So we come back to this 25-person indictment in Southern California. Clearly, some of them are more culpable than others. Others were directly involved. It's like $150 million alleged fraud. So there's a lot of players here. I told one of the defendants, who was very much on the periphery, that he could get a longer prison term than someone who was more involved. And he's like, well, that's crazy. I was only involved for like 3 months. This guy did it for years. That doesn't make any sense. That's not justice. So walk us through the value of speaking openly or potentially cooperating regardless of your role.
Absolutely. And that really underscores the nature of the federal sentencing system. Although the guidelines that everyone talks about are no longer mandatory, the reality is these judges grew up in a time when those sentencing guidelines were mandatory. So what you see is, even though judges have great discretion in sentencing someone within the statutory range, the recommended guideline range within that statutory range, which is a function of a person's bad acts and their criminal history, it comes up with a much narrower score within the statutory range. That's where judges often end up when they're looking at sentencing, if not at the very end, at least as a starting point. That's where they start. The kind of exception to that, even for judges who grew up in a mandatory sentencing world, is this idea of proffers. And by proffer, I mean a person has gone in and spoken with government agents and provided something of value. In many courts, the way many judges look at this, you have to provide enough value to where a prosecutor is willing to say they not only gave us truthful information, but that information led to an arrest or multiple arrests. Or, hey, we had 3 people who were otherwise going to go to trial that are now entering pleas of guilty, and we're avoiding trials because of this person's proffer. So it's truthful information, it's valuable information that the government can say they got something from. So they would file a motion with the court. So if you hear a 5K or a 5K letter, that's what they're talking about. The government is acknowledging that you have provided something of value. the way your more culpable individuals end up with better sentences than the people at the very bottom is they understood the value of a proffer and they got in early. One of the things I tell my clients all the time is you want to be first in line. If there's 25 people in this indictment, let's say you know something of value, but 3 other people tell the government agents before you ever get to them, well, you've lost any value that you had. So it's about being truthful and it's about moving quickly. You don't want to sit on the information that you have or take a month to finally understand what your attorney's been trying to tell you. I've had clients go both ways, and what I usually tell them is these are 2 paths in front of you. You can proffer, you can cooperate, and here are the kind of outcomes that I have seen for people who cooperate. Or you can stand by this idea of I'm never going to snitch, I'm never going to talk.
The prison parlance of the snitching and all that stuff.
Exactly.
I still hear it.
And they end up with much higher sentences.
Yes.
I won't twist anyone's arm, but I'm going to be as clear as I possibly can be that in most conspiracy allegations, proffering is perhaps the most valuable thing you can do for yourself.
Well, those are important points. My co-conspirator cooperated against me. I didn't have a choice. And people ask me, am I upset? And my response was, he was married with 4 children. He did what was in his best interest. It was a values play for him. I don't begrudge him that. I forfeited that opportunity by lying to the FBI. Okay, let's make our way towards the end of this video. I want to talk about a couple of points because we're going to do more videos in the future. Let's talk about post-defense conduct. And I consider post-defense conduct between indictment and sentencing. And the record I think a defendant can begin to create. And I know that's part of what I'm going to discuss at the conference, of sentencing videos, of narratives. But Big Brother, once you've been indicted, is watching social media, posts that are taking place. Are they working? Talk a little bit about the post-defense conduct and how you advise clients, knowing that, like I just said, Big Brother's on them. Can't have any more problems.
Sure. Unlike many other federal cases, one of the unique things about most white-collar cases is your client is likely, there's a good chance that they will actually be out of custody while this case is pending and set for sentencing. Mm-hmm. And everything you do is under a microscope. Mm-hmm. We look at that as an opportunity. Mm-hmm. What you're doing, who you're talking to, whether or not you're doing community service, whether or not you're entering into drug rehabilitation, whether or not you're putting together the best mitigation packet humanly possible. Thinking outside the box, whether it's videos, showing the judges more than you tell them, or at least as much as you tell them. All of that's of great value. And the opposite's also true. If you are alleged to have committed more offenses while you're out, if you have a dirty urine analysis, if probation has a negative report about you, those things are not only going to cut against whether or not you remain out of custody, but could very well be a new offense that they file against you, and it can certainly affect your sentencing. And at the very end, when you get to sentencing, one of the things you're trying to show the judge is your remorse for any wrong acts that you've committed. And it is going to kill your credibility if you're still out there committing new offenses or are alleged to have used drugs. But if you're in that true minority of people that have taken every single step that is humanly possible to cast yourself in the best light, the judge is going to take that into account. And you want the judge to struggle. You want the judge to say, yes, I know there was this bad conduct, but look at everything this person has done since that time to show me, not just tell me, but to show me that there's something different about their life.
Well, as we close, can you give us a 30-second or 45-second little clip or promo about this phenomenal conference that you're putting on this week and why you decided to create this conference and bring so many white-collar defense attorneys together?
Absolutely. Well, first off, thank you for agreeing to come speak to the group that's coming. We are so excited to have the White Collar Seminar again this year. This is our second year to do it. I decided to put it together because when we started, the only places you could go for real white collar training was, destination locations. So one of the coasts, maybe DC or New York. But we've got really good defense attorneys. We've got really good prosecutors here in Texas and in central United States, and we wanted to bring them together so that they could put on their best cases to really learn, especially from the defense side, what's successful, how are we thinking outside of the box, how are we really using everything that's available to us to put our clients' stories in front of the judges in a meaningful way. So we've got prosecutors who will be presenting, defense attorneys who will be presenting, a panel of judges. You'll be presenting. We are so excited about it. And once again, thank you. And for anyone that's interested, it's whitecollarseminar.com.
I'll put up a link to it. I'll close with, I filmed a video a couple of months ago called 12 Questions to Ask a Lawyer. It's gotten a lot of attention. I assure you that Benson answered the questions properly. He's certainly someone you should consider. And even if you're considering retaining a lawyer outside of Dallas or wherever you may be, I'm sure he has a network across the country. So if you're in Chicago, New York, he can help locate someone and go through a vetting process. So Benson, I look forward to shaking your hand at the conference this week, and thank you for contributing to the White Collar Advice channel.
Thanks for having me again. Look forward to seeing you.
Okay, bud.